For today's coverage, we turn our attention to freedom of speech by commercial providers. This is Masterpiece Cake Shop Part 2, better known as 303 Creative. It's basically fundamentally the same underlying issue. You'll remember Masterpiece Cake Shop. A guy walks into Masterpiece Cake Shop and be like, I want you to design me a custom cake for my gay wedding, right? And the guy's like, no. You can have one of my cakes that I've already pre-made. They're on the shelf. Or if you want a standard design cake, I have a lot of standard design cakes. So you can have one of those. But I'm not going to make you a special cake for your gay wedding because I don't believe in it. So if you want one of my off-the-shelf cakes, literally off the shelf right now, or one that I would make typically, no problem. But I'm not going to make a special cake just for you. And there was a whole lawsuit about it. And of course, the Supreme Court somewhat famously punted. Now we're back with part 2, known as 303 Creative. A guy walks to a website designer and be like, hey, website designer, I want you to make me a website for my gay wedding. And website designer's like, no, I don't want to do that. I don't want to make your gay website because I don't really believe in the gay marriage personally. I'm not going to do that. And the person's like, you can't just do that. You're discriminating against me in a way that's protected by state law. You can't discriminate against me on the basis of my sexual orientation or sexual preferences because those are protected categories. And they're like, yes, I can, because state law, which protects all that stuff, is interesting and all. But First Amendment beats your state law because federal law beats state law. And of course, now we have a lawsuit. So it's Masterpiece Cake Shop, Part 2, 303 Creative. Is it a gay cake? Is it a gay website? Can we be forced to make the gay thing? Let's learn more about this. Laurie Smith wants to expand her graphic design business, 303 Creative, to include services for couples seeking wedding websites. So she provides websites for all kinds of purposes. She doesn't normally do wedding stuff. That's a specialized market. And she's like, but I'd like to expand out my market. I'd like to get into the wedding stuff. So I don't normally do wedding stuff at all, but I'd like to expand. Okie dokie. But Miss Smith worries that Colorado will use the Colorado Anti-Discrimination Act to compel her, in violation of the First Amendment, to create websites celebrating marriages she does not endorse. To clarify her rights, she files a lawsuit seeking an injunction to prevent the state from forcing her to create a website celebrating marriages that defy her belief. That should be reserved to unions. Well, she has a pretty good basis for believing that Colorado will force her to make the websites because of Masterpiece Cake Shop, which was also Colorado. So she takes note of, Masterpiece Cake and all that fun, exciting stuff. And she's like, okay, I'm going to strike first. I'm going to sue you, Colorado, first. Declaratory relief. I believe that there's enough threat to me that I can sue you. And, there's various cases dealing with that. But in view of Masterpiece Cake Shop and all that fun and exciting stuff, the court below found no problem saying, yep, there's enough threat to you. They haven't sued you first, but you can sue them, right? There's enough of a dangling sword over your head, enough sword of Damocles that you can file suit. So we will recognize your suit as you strike first. The relevant law prohibits all places of public accommodation from denying full and equal enjoyment of goods and services to any customer based on race, creed, disability, sexual orientation, or other statutorily defined trait under Colorado specific law, which of course is not a problem. The federal law may or may not require this. Doesn't really matter. Colorado wants to extend more rights. And of course, Colorado can do that. It's not a problem. The federal law says discrimination is bad. Colorado wants to say it's more bad. Fine. No problem. Colorado can do that. The law defines public accommodation broadly to include almost every public-facing business in the state. No problem. You want to do business. You accept business from the public. Here are the rules. Cool. Either state officials or private citizens can bring actions to enforce the law. Totally fine. We want to enable private people to bring lawsuits. That's cool. And a variety of penalties can follow any violation. All this sounds really, really fine. Of course, there's a problem, though. There's a problem in this specific domain because 303 Creative, as the name somewhat implies, is producing speech. You know, they're not just selling cars, they're not just selling widgets, they're selling speech, specifically speech that they themselves will create for you. For you. And so Colorado can do all those things, but First Amendment though. Right? So now we have the principle of non-discrimination, which we can extend, but now we're running into the First Amendment. Okay, before the district court, the parties stipulate to a whole bunch of facts. So, we'll just stipulate to a whole bunch of things, which, fine, because we want to get to the underlying legal issue. There's not really a factual dispute here. So let's just agree to the facts. Great. Ms. Smith is willing to work with all people regardless of classification, such as race, creed, sexual orientation, and gender, and will gladly create custom graphics and websites for clients of any sexual orientation. She will not produce content, however, that's contrary to biblical truth, regardless of who orders it. Ms. Smith's belief is that marriage is a union between one man and one woman is a sincerely held conviction, which is something we could incidentally fight, by the way, on the case law. So you could fight that she doesn't really believe it. That is something you can do, right? You can't get into whether the beliefs themselves are true or not, but in sort of their ultimate sense. But you can get into the issue of whether the person is fronting. It's like, oh yeah, I believed in these things, right? Do you really though? Do you? But we're not going to fight that issue. She really believes it. We agree with that. Okay, great. Ms. Smith provides design services that are expressive, and her original customized creations contribute to an overall message her business conveys through websites it creates. The wedding websites she plans to create will be expressive in nature, which is kind of hard to avoid to some degree. I suppose you could have some sort of like purely utilitarian wedding website, but who would want it? And it will be customized and tailored through close collaboration with individual couples. And it will express Ms. Smith's and 303 creative messages, celebrating and promoting her views of marriage. Viewers of the websites will know that her websites are original artwork. There are numerous companies in the state of Colorado and across the nation that can offer design services. So, it's not like she's the only game in town, either literally or figuratively. Because, of course, in this increasing internet age, you don't necessarily need to buy from her or literally anyone else in Colorado. Because, who will design the website for me? Oh, gee, where will we ever find someone, So there are alternatives in the marketplace. Ultimately, the district court held that Ms. Smith was not entitled to the injunction, and the 10th Circuit affirmed. So, Ms. Smith, you lose. You can't get your injunction. You have to design the gay wedding websites. Okay, what does the Supreme Court have to say? The First Amendment prohibits Colorado from forcing a website designer to create expressive designs speaking messages with which the designer disagrees. Hooray! First Amendment runs the day. Now, this case is a little bit better in a technical reason than Masterpiece Cake, because this is more pure speech. One of the problems with Masterpiece Cake is that we're selling a cake. Okay? Now, can the cake have speech elements to it? Probably, yes. But there's a bit of a line drawing problem, and this is a problem that we experience below in the lower court. So Masterpiece Cake was not necessarily the best case to hear this case because it runs into this problem of, well, where does speech start and where does it stop when it comes to an item which is utilitarian? Like the fundamental item in Masterpiece Cake is utilitarian. It's a cake. It's a useful article. It is useful for being tasty and enjoyable. All right. Does it have speech elements? Probably, but it's primarily utilitarian. And so we ran into this problem where it's like, okay, what if instead of a cake designer, what if they're a fabric designer and they make custom wedding suits? What if they make custom wedding shoes? How about florists, right? How about florists because they pick particular flowers to represent particular things, right? So we get into this. How do we separate out the speech element from the utilitarian element? Because the flowers are flowers. They are there to look pretty and nice. Do they express a message? Maybe, but fundamentally they're flowers. Fundamentally they're cakes. Fundamentally it's a suit. Fundamentally it's shoes. So Masterpiece Cake Shop, in some senses, is what we say in the trade is not a good vehicle to decide the issue because there's a bit of a line drawing problem. 303 Creative is a better vehicle to decide the issue because we don't have that problem. The thing is the speech. It's just speech. It's speech all the way down, right? It's a website. It's speech, right? The fundamental thing is speech in its nature. So we don't have this problem. So this case is a better issue. So how this case will read on to a case like the cake case or other hypotheticals, somewhat still to be decided in some ways. But this case is a better vehicle. So they attack the pure issue, and then how that applies to more mixed issues will have to be more as an as applied thing as we deal with the mixing. But that's one of the reasons why I think the Supreme Court kicked the Masterpiece Cake Shop, because it led to some problems that were not ideal. And rather than deal with the problem, the Supreme Court, because it gets to choose its cases, said, let's just deal with the pure thing. And this is about as pure as it gets, right? This is about as pure speech without any sort of complications as you can get. So dealing with the pure speech issue where there is no other complications, the Supreme Court says, yes, you can't be forced to create speech. Fantastic. The framers designed the free speech clause of the First Amendment to protect the freedom to think as you will and speak as you think. The freedom to speak is among our inalienable rights. The freedom of thought and freedom of speech is indispensable to discovery and spread of truth. For these reasons, if there's any fixed star in our constitutional constellation, is the principle that the government may not interfere with uninhibited marketplace of ideas. This court has previously faced cases where governments have sought to test these foundational principles. In Barnett, the court held that the state of West Virginia's efforts to compel school children to salute the nation's flag and recite the Pledge of Allegiance invaded the sphere of intellect and spirit, which is the purpose of the First Amendment to reserve from all official control. State authorities have transcended constitutional limitations on their powers. In Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, the court held that Massachusetts' public accommodation statute could not be used to force veterans organizing a parade in Boston to include a group of gay, lesbian, and bisexual individuals because their parade was protected speech, and requiring the veterans to include voices they wish to exclude would impermissibly require them to alter expressive content of their parade. So yeah, not necessarily the first pure speech issue dealing with these issues, public accommodation, but yes, the Hurley wanted to have a parade in Boston for the veterans. It's like, veterans are good. We like veterans. Let's have a parade for the veterans. Yay. And then some group of them wanted to be like, hey, we're bisexual, lesbian, and gay veterans. We want to march in your parade. And they're all like, nah, though, because I don't want to celebrate that particular conduct. You may or may not, you may be veterans or whatever, but that's not really the message of my parade. And they tried to force it. No, you will have our gay soldiers in your parade. Your parade will become even more gay than you ever dreamed. And the Supreme Court is all like, no. Look, guys, I appreciate that you want to be gay, lesbian, and bisexual veterans or whatever, but this is their parade, literally, and you can't force their way into their parade any more than they can force their way into your parade. If you want to have your gay, lesbian, bisexual veterans parade, knock yourself out on your own time, right? You can have your parade. We're not saying you can't have your parade. You just can't force your way into their parade. You know, they want their message. Don't you want the ability to have your message? You want them to be able to force their way into your parade? Is that what you want? Because that sounds really dumb. So their particular message is only the straight veterans. Is that a good message? I don't know. It's a message, though. And if you don't like that message, you can protest it. You can have your own parade, but you can't force your way into their parade. Not so much. And in Boy Scouts of America, when Boy Scouts sought to exclude an assistant scoutmaster from membership after learning he was gay, the court held Boy Scouts to be an expressive association too. So Boy Scouts, once upon a time, thought, how about only boys and only men in the Boy Scouts? A position today that they don't hold as much, which, you know, is a prerogative of the Boy Scouts. The Boy Scouts can choose. The Boy Scouts today are like, how about the girls? The girls can join the Boy Scouts. We call them Scouts now. as we slowly try to overtake the Girl Scouts and make them irrelevant, which is kind of hilarious. But once upon a time, the Boy Scouts were like, okay, we are a group for the men. We're a group for the boys, and we want to teach traditional boyship, traditional menship, and not so much with the gay scoutmasters. It's like that, you can't do that. You can't exclude them from your group. And Supreme Court's all like, yes, you can. They're a private association. They want to have the group they want to have. If you want to have the gay scout group, go crazy, have your own. You can have your own scout group, but you can't force your way into their scout group. So the fact that the Boy Scouts would later change their mind is kind of irrelevant, because hypothetically, of course, the Boy Scouts could also change it back. They could also be like, well, that was dumb. We shouldn't have done that. Let's go back to the old ways. It's up to them. They're a private organization. They can do what they want. You can't force your way into their parade. You can't force your way into their private organization. No. The court found that forcing the Scouts to include Dow would undoubtedly interfere with its choice not to propound views contrary to its beliefs. These cases illustrate that First Amendment protects an individual right to speak their mind, regardless of whether the government considers the speech sensible, well-intentioned, or deeply misguided, likely to cause anguish or incalculable grief. Generally, a government may not compel a person to speak its own preferred messages. So, yes, this does not depend, as one would expect, on the government or anyone else agreeing with your message. The government may agree with your message. They may think it's the greatest message ever, which, at that point, you don't really need the First Amendment, because everyone's sort of happy. The First Amendment doesn't really matter if the government thinks it's great and everyone else thinks it's great. If everyone supports the message, you don't really need the First Amendment. The government may think that, or they may think exactly the opposite of that. They may think it's misguided, or even likely cause anguish or incalculable grief, or misperceived or whatever. But we allow people to spread their own messages regardless of what anyone else thinks about it. You get to spread your own messages too, by the way. So this is not, you don't get to say you don't like it. You can absolutely say you don't like it. You can say those are misguided. You can protest. You can have your own speech. That's great. But you can't force them to stop speaking just because you don't like what they want to say. You can't force them to say the words you want to say. Applying these principles to the stipulated facts, the court agrees with the 10th Circuit. The wedding website Ms. Smith seeks to create qualifies as pure speech, which it is. And by the way, when I say pure speech, I mean it's not mixed, because it's not the Masterpiece Cake Shop. This is not a utilitarian article, the cake, mixed with some First Amendment along the way, because when does the cake become a First Amendment thing? That's a reasonable question. Is the standard off-the-shelf standard white cake, is that a First Amendment thing? What if it's a black cake or a pink cake? Is that speech? I honestly don't know, by the way. I'm asking because the question is unclear. If whatever the standard off-the-shelf cake is that freedom of speech? And what if we start putting writing on it? When does it become speech again? So where does the speech start and where does the speech stop is a thorny question. We don't have that problem here because this is pure speech. This is speech all the way down, no complications. Miss websites will express and communicate ideas, namely those that celebrate and promote a couple's wedding and unique love story, and those that celebrate and promote what Miss Smith understands to be marriage. Speech conveyed over the internet, like all other manner of speech, qualifies for the First Amendment. Yeah, just because it's the internet doesn't mean the First Amendment doesn't apply. The First Amendment does apply to the internet. And the court agrees with the 10th Circuit that wedding websites Miss Smith seeks to create involve her speech, a conclusion supported by party stipulation, including that Miss Smith intends to produce a final story for each couple using her own words and original artwork. While Miss Smith's speech may be combined with a couple in a final product, an individual does not forfeit protection by combining multiple voices into a single communication. So is it Mrs. Smith's speech alone? Well, probably not, right? She's going to talk with the couples, and it's going to be based off their wants and their desires and their dreams, right? She's going to design a website that is in some sense tailored for them, because if not, again, no one will want to buy it. She's just producing websites that are somewhat generic. That might be a product that someone might want, I suppose, but Most people are going to want something more customized. So her speech will be combined with other people's speech. That's true, but it doesn't mean that her speech is any less important. Ms. Smith seeks to engage in protected First Amendment speech. Colorado seeks to compel speech she does not wish to provide. As the 10th Circuit observed, if Ms. Smith offers wedding websites celebrating marriages she endorses, the state intends to compel her to create custom websites celebrating other marriages she does not. Colorado seeks to compel the speech in order to excise certain ideas or viewpoints from the public dialogue. Indeed, the 10th Circuit recognized that the coercive elimination of dissenting ideas about marriage constitutes Colorado's very purpose in seeking to apply the laws to Ms. Smith. But while the 10th Circuit thought that Colorado could compel speech from Ms. Smith consistent with the Constitution, the court's First Amendment precedent teaches otherwise. In Hurley, Dale, and Barnett, this court found that governments impermissibly compel speech in violation of the First Amendment when they try to force speakers to accept messages with which they disagree. Here, Colorado seeks to put Ms. Smith to a similar choice. If she wishes to speak, she must either speak as the state demands or face sanctions from expressing her own beliefs, sanctions that may include compulsory participation in remedial training, filing periodic compliance reports, and paying monetary fines. This is an impermissible abridgment of the First Amendment's right to speak freely. Under Colorado's logic, the government may compel anyone who pays for a given topic to accept all commissions on that same topic, no matter the message, if the topic somehow implicates a customs statutorily protected trade. Taken seriously, that principle would allow the government to force all manner of artists, speechwriters, and others whose speech involve services who involve speech to speak which they do not believe on pain of penalty. So yeah, this is of course not just about 303 Creative. This is of course about anyone who's at least pure speech. This would be artists, when they're painting, like the painting is the point, right? The painting is its art, like it is non-utilitarian. Art is non-utilitarian in its nature. It is not useful. It is pretty and it sends a message. It is not a useful article. One of the reasons, incidentally, that patent protection for a piece of art makes no sense. It's copyright because it's expressive. It's not useful. So art is not useful in a technical sense. Speech writing, not useful in a technical sense, right? It doesn't do anything. It doesn't serve anything. It can't be eaten. It can't be consumed. It can't be used. It doesn't change a chemical, right? A speech is non-useful in a technical sense. It is pure expression. So if Colorado was right, artists, speechwriters, magazine publishers, book publishers, anyone would be bound by this to express all kinds of views they may not agree with. To be sure, public accommodation law plays a vital role in realizing the civil rights of all Americans, and governments in this country have a compelling interest in eliminating discrimination in places of accommodation. This court has recognized that public accommodation laws vindicate deprivation of personal dignity that surely accompanies denials of equal access to public establishments. The court has recognized that public accommodation laws vindicate the deprivation of personal dignity that surely accompanies denial of equal access to public establishments. Over time, governments in this country have expanded public accommodation laws in notable ways. Statutes like Colorado's grow from non-discrimination rules. The common law sometimes imposed on common carriers and places of traditional public accommodation like hotels and restaurants. Often, those enterprises exercise something like monopoly power or hosted or transported others or their belongings. Importantly, states have also expanded their law to prohibit more forms of discrimination. Today, for example, approximately half the states have laws like Colorado that expressly prohibit discrimination on the basis of sexual orientation. The court has recognized this as unexceptional. States may protect gay persons just as they can protect other classes of individuals, and acquiring whatever products and services they choose on the same terms and conditions as are offered to other members of the public. And there are no doubt immeasurable goods and services that no one could argue implicate the First Amendment. At the same time, this court has also long recognized that no public accommodation law is immune from the demand of the Constitution. In particular, this court has held public accommodation statutes can sweep too broadly when deployed to compel speech. As the 10th Circuit saw it, Colorado has a compelling interest in ensuring that equal access to publicly available goods and services and no option short of coercing speech from Ms. Smith can satisfy that interest because she plans to offer unique services that are, by definition, unavailable elsewhere. In some sense, of course, her voice is unique, so is everyone's. But that hardly means the state may co-opt an individual's voice for its own purposes. The speaker in Hurley had an inviolable outlet for speech, and the Boy Scouts in Dale offered an arguably unique experience. But in both cases, this court held that the state could not use its public accommodation statute to deny a speaker the right to choose content of his own message. A rule otherwise would conscript any unique voice to disseminate the government's preferred art messages in violation of the First Amendment. Colorado now seeks to acknowledge the First Amendment does prohibit it from coercing Ms. Smith to create websites expressing any message with which it disagrees. Alternatively, Colorado contends Ms. Smith must simply provide the same commercial product to all, which she can do by repurposing websites celebrating marriages she does endorse for marriages she does not. Colorado theories relies on a belief the case does not implicate pure speech, which is some bullshit, by the way, because it's pretty hard for this to be not pure speech. This is about as pure speech as it gets. But rather the sale of an ordinary commercial product, yeah, that's some bullshit. And that any burn on Miss Smith's speech is purely incidental. No, this is no. Like, again, if we were dealing with this mixed stuff, like if we were trying to draw the line between speech and non-speech as we embed the speech into useful articles, if we were doing that, then yeah, we might talk about something incidental to the First Amendment. But this is not incidental because this is not mixed. This is about as pure speech as it gets. On the state's telling, then, speech more or less vanishes from the picture, and with it, any need for the First Amendment scrutiny. That's a neat trick. The First Amendment vanishes from this pure speech exercise. Wow. Colorado's alternative theory, however, does not sit easily with its stipulation that Ms. Smith does not seek to sell an ordinary commercial good, but instead to create a customized and tailored expressive speech for each couple to celebrate and promote the couple's wedding and unique love story. Colorado seeks to compel just the sort of speech it tacitly concedes lies beyond its reach. The state stresses that Ms. Smith offers her speech for pay and does so through 303 Creative LLC, a company in which she's the sole member owner. But many of the world's great works of literature and art were created with an expectation of compensation. Yeah, just because you're getting paid for it doesn't mean that it doesn't become art. So art may indeed be valuable, but it is not useful. And speakers do not shed their First Amendment protections by employing the corporate form to disseminate their speech. Colorado urges the court to look at the reason Ms. Smith refuses to offer the speech it seeks to compel, and the claim it reasons that she objects to protected characteristics of certain customer. But the party stipulations state, to the contrary, that Ms. Smith will gladly conduct business with those having protected characteristics, so long as the custom graphics and websites she's asked to create do not violate her beliefs. Ms. Smith stresses that she does not create expressions that defy any of her beliefs for any customer, whether that involves encouraging violence, demeaning another person, or promoting views inconsistent with her religious commitments. The First Amendment protections belong to all, thank God for that, not just to speakers whose motive the government finds worthy. Yeah, that's kind of the exact opposite of the First Amendment. The entire point of the First Amendment is to protect speech the government does not find worthy, because if the government finds it worthy, you don't need the First Amendment. The First Amendment only really exists to the extent it applies to speech the government does not like. If the government likes it, you don't need no First Amendments. What are we talking about? In this case, Colorado seeks to force an individual to speak in many ways that align with its views, but defy her conscience about a matter of major significance. In the past, other states in Barnett, Hurley, and Dale have similarly tested the First Amendment boundaries by seeking to compel speech they thought vital at the time. But abiding the constitutional commitment to freedom of speech means all will encounter ideas that are misguided or even hurtful. Yes, some speech may not be good. Some speech may even be detrimental. But, you know, that's how we work. Yeah, we allow that speech. That's the point. Consistent with the First Amendment, the nation's answer is tolerance. Nice, not coercion. So we teach the so-called tolerant what tolerance really looks like. It means you have to appreciate the speech you don't like. No, not that kind of tolerance. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Colorado cannot deny that problem consistent with the First Amendment. Gorsuch delivers the opinion of the court, go Gorsuch, in which Sotomayor, Kagan, and Jackson, not understanding the First Amendment, dissent. Thus, that brings us to the end of 303 Creative, a case dealing with free speech and pure speech in the form of a website, which is about pure speech as you can get, right? We don't have the problem of this being some sort of mixed thing where we're dealing with the cake or the suit or the shoes or some other thing which has a useful effect, right? Where we embed the non-useful speech into the useful article, and we have to separate the two, right? In this case, we have no useful article. This is pure speech. It has no utility. It is just speech unto itself. It may have value, but it has no utility. And that means that the Supreme Court can decide the issue as to a pure speech thing, which they just did, and said, yeah, you can't compel speech, which seems like a pretty obvious conclusion, even as 3 members of the court apparently want to force that. So that's fun. And that brings us to the end of discussion of this case.